Before we get started, let's talk for a second about the DMCA bill. In 1984, it was none other than Prince himself who stumbled upon a 29-second home video of a toddler with his song Let's Go Crazy in the background. He then began a high-profile legal shutdown involving YouTube, Universal Music Group, and a Pennsylvania housewife. The legislation called the Digital Millennium Copyright Act, or DMCA, was then signed into law by President Bill Clinton on October 28, 1998. It was heavily supported by content industries like Hollywood and record labels. It was written in order to strengthen existing federal copyright protection against new threats posed by the internet and technology. The world was changing, society was changing, technology was changing, and therefore the laws had to change with it. It was this provision that the operators of file-sharing platforms tried to hide behind during their unsuccessful attempts to defend themselves against DMCA-inspired litigation in the early 2000s, which leads us to the topic at hand, Napster. Despite Napster's argumentation about maintaining DMCA 512A, the plaintiff, A&M Records, points out that not all of Napster's functions fall under the safe harbor subsection. In summary, 512A limits the liability of service providers in circumstances where the provider merely acts as a data conduit, transmitting digital information from one point of a network to another at someone else's request. This limitation covers active transmission, routing, or providing connections for the information, as well as the intermediate and transient copies that are made automatically in the operation of a work. In order to qualify for this limitation, service provider activities must meet several conditions. The transmission must be initiated by a person other than the provider. 2. The transmission, routing, provision of connections, or copying must be carried out by an automatic technical process without selection of material by the service provider. 3. The service provider must not determine the recipients of the material. 4. Any intermediate copies must not ordinarily be accessible to anyone other than the anticipated recipients and must not be retained for longer than reasonably necessary. And 5. The material must be transmitted with no modification to its content. The plaintiff states that each one of these parts in 512 need to be looked at individually according to 512N, and through this analysis it is evident that Napster does not fall under the safe harbor guidelines. According to DMCA's 512K, a safe harbor and service provider is an entity offering the transmission, routing, or providing of connections for digital online communications between or among points specified by a user of material of the user's choosing, without modification to the content of the material as sent or received. Or, it can also be understood as a provider of online services or network access, or the operator of facilities. Regardless, the plaintiff believes Napster cannot fall under 512A because of a few things. 1. Napster does not perform the function of transmitting or routing through their system as required by 512A, and therefore cannot qualify as a safe harbor. However, even if the defendant were to argue that the user's computers are part of Napster's system, then the MP3 files would be stored on the system longer than needed, therefore not abiding by 512A4. Secondly, 512A is not a blanket system, and due to the defendant's information location tools, their service is less about 512A and more so outlined in 512D. 512D relates to hyperlinks, online directories, search engines, and the works, and limit liability for the acts of referring or linking users to a site that contains infringing material. If using information location tools, the following conditions must be met. Number 1. The provider must not have requisite level knowledge that the material is infringing. The knowledge standard is the same as under the limitation for information regarding the system or networks. 2. The provider has the right and ability to control the infringing activity, and the provider must not receive a financial benefit directly attributable to the activity. 3. Upon receiving a notification of infringement, the provider must take it down or block access to the material. 512D contains more demanding requirements because it covers active assistance to users. Despite the defendant's disagreement, it is clearly evident that Napster serves as a transient list of files available to all users, a search index, and a free information location service hotlist, meaning users are able to search for other users' login names, locations, and receive notifications in order to communicate with them. In addition, to be eligible for any of the limitations, a service provider must meet 2 overall conditions. 1, it must adopt and reasonably implement a policy of terminating inappropriate circumstances of the accounts of subscribers who are repeat infringers. And 2, it must accommodate and not interfere with standard technical measures outlined in subsection 512I. Standard technical measures are defined as measures that copyright owners use to identify or protect copyrighted works. that have been developed for a broad consensus of copyright owners and service providers in an open, fair, and voluntary multi-industry process, are available to anyone on reasonable non-discriminatory terms, and not impose substantial costs or burdens on service providers. The plaintiff contends that Napster only adopted its copyright compliance policy after the onset of legal action, and even now is neglecting to discipline infringers. In the end, the court sided with the plaintiff, or the argument of the majority, and determined that Napster was unable to meet the requirements of 512A. The defense's motion was denied.